Hi, I'm Tony Munter, and I get asked all the time, how much is my whistleblower case worth? Well, it's a really good question and an important one, and of course it depends a lot on the type of case a client brings and on the law that the case is brought. Basically, a case under the Federal False Claims Act is worth whatever the government has suffered as a damage. That can be a little complicated to determine, of course, but it can get to be a very valuable and large case very quickly. Under securities fraud, it's a similar issue with the SEC whistleblower program. How much have investors been defrauded is the question to determine how much the case is worth. Now, those numbers don't mean the case is worth that to the whistleblower personally. Whistleblowers collect a share, that is to say a percentage, of any collection made by the government. The government obtains the lion's share of any award, as they should. They're the real party in interest when it comes to a False Claims Act case, for example. But the larger the case, the more the government has suffered, the larger the case of securities fraud, the more that investors have suffered, the larger your case may be worth. It's a matter to take up with your attorney when you first discuss the issues with them. You want to be able to bring a large case if you possibly can. Even the government takes into consideration the size of a case when determining what actions it may take. There is one sort of caveat to this. Those of us who are whistleblower lawyers like to argue that there is no limit, there is no requirement for a base level under the False Claims Act for liability to accrue. Still, even under the False Claims Act, and even under the terms that say that liability accrues even when there are no damages, it's a good idea to determine what's involved, how much money is involved in your case before making the difficult decision as to whether to file a case under these laws.